Okay, guys, here we go.
Breaking news! Breaking news!
You know, sometimes I feel like DJ Khaled. You know who DJ Khaled is, Rich?
No.
Probably have no idea. And another one. And another one. All right, guys. So the Second Circuit has given us another decision. This is actually the third decision that they given out, and this is, I don't know, man. This what?
Nothing.
No, I didn't cover all three because one was basically a copy of the other one. They're actually fourth because one was muted, so mooted the FBC case because it was similar to the Antioch case. So let's go ahead and bring this up. It, of course, is in, and it was, oh, damn it. Did I bring up the wrong one? All right, hold on. I uploaded the wrong one. All right, just give me 1 second.
And for those of you asking, Dark is not sleeping. Ooh, are we breaking news? Is it world peace? Is that the story?
Yeah. No.
Maybe not.
Okay, I put the wrong one in the I'll link this and I'll fix it later. In the source.
Dark is not sleeping. See, we have proof.
No, I just talked to him. He just texted a few minutes ago. This isn't California. This is New York again. It is uploading. This case is Gonzalo versus Hochul. Paloma, good friend of the show and of the channel, is the lawyer of record in this case, and I'm just trying to get it to pull up here. It's giving me a hard time. Of course it is. Why wouldn't it? If you recall, this case deals with background checks and everything else like that.
So it was part of the SAFE Act in New York.
Yeah.
So, let's see.
All right, I got it right. Oh, hold on. This sucks. You know, I'm gonna try to share it this way.
So in New York, an SKS with an ATI folding and telescoping stock is legal with a 10-round fixed mag. But if you have the 20-round fixed or the duckbill removable 30-round mag, not legal.
All right, just bear with me, guys. I'm sorry. I just have to pull up Pacer. All right, so this is a case here. I'm going to go ahead and share it. And fuck did it go? Oh, I'm sorry. I should not use that language. Here we go. I got it. I'm going to bring it up right now.
Get it up, Crump.
This is in the Second Circuit Court of Appeals. But this
Which is the Communist Court of Appeals.
Yeah, this is challenging, whatever. And go ahead and read this right here.
Plaintiffs' appellants are 8 firearms and munition dealers, 1 firearms pawnbroker, and 1 business organization. They appeal from an order of the United States District Court of Northern District Court of New York, Brenda, whatever, denying the motion, preliminary injunctive
Okay,
relief.
so stop right there. All right, basically what happened is they wanted to have a preliminary injunction against the state of New York for doing background checks on ammunition and stuff like that because the system is so broken that it was actually affecting their business. Paloma Capana is a friend, and she represented eight different stores, gun stores, and they lost their suit in the 11th in the district court, Northern District Court of New York. So they appealed to the Second Circuit. They had a briefing at the Supreme Court level to try to get the Supreme Court to step in, but they decided to let the Second Circuit do their business. So let's go and see exactly what they do, because there's more than that than just ammunition. So go ahead and read.
First appellants claim that New York's commercial law regulating the sale and transfer of firearms are too onerous and thus will financially burden the plaintiffs to a point they will be forced out of business. They say that in turn threatens their customers' right to acquire firearms in violation of the Second Amendment. The laws to which they object require them to secure firearms in a locked, fireproof safer vault outside of business hours.
Basically, you can't. You have to have a fireproof safe or vault. You just can't have like a secured room or fortified room. It actually has to be in a lock system. You also have to have alarms and everything else. And you have to provide this police training that the police develop for all your employees. You have to do monthly checks and inventory. Basically, the state police is going to inspect your store once a year.
Gestapo?
Not the ATF, but the state police. A minor cannot be in the store without a illegal adult, and you can't hire 18-year-olds or 20-year-olds. They have to be 21.
Oh, wow.
Yeah, so there's a bunch there. Second claim, go ahead.
Second, they claim New York law is preempted by federal law in 3 ways. 1, by requiring all FFLs to devise a plan for securing firearms even while those firearms are in shipment. Whoa. By directing FFLs to maintain records of sale and inventory information and submit those records to the state police on a semi-annual basis, and by setting up background check system that will result in a misuse of the National Instant Criminal Background Check System, principally by
for ammunition sales. NICS was never meant to do ammunition. It was only meant to do firearms. All right, you go from appellant.
Appellants report the federal law 1 relieves an FFL of responsibility over the security of firearms that are in shipment if the FFL is merely receiving as opposed to sending firearms, prohibits the Attorney General by extension from the states from requiring routine reporting of sale in inventory record, prohibits the use of NICS to conducting background checks in ammunition sales.
What they are requiring is they are requiring FFL to take responsibility for firearms being shipped to them, even though they have no way of determining, safeguarding that on the way to them,
That's
especially if
crazy.
it's shipped from, like, if you order something online and you get shipped in to do a transfer, that FFL is responsible for the firearms.
So FedEx misplaces a firearm shipment, the FFL is responsible.
Yeah. Okay. Read the third.
Third, appellants claim that New York law violates their Fifth Amendment right to be free from self incrimination by requiring them to annually certify their compliance with New York state law. They claim that such certification is impossible because if they were to comply with New York law, they would necessarily violate federal law. We understand this claim to rest on their preemption theories.
They claim that the plaintiffs claim that the federal law preempts the state law.
Correct.
That's probably the weakest argument.
Fourth, appellants claim that New York law violates their Second Amendment rights as individuals by requiring them to obtain a special license to possess semi automatic rifles, undergo background checks to purchase ammunition, and undergo firearms training to renew their concealed carry licenses.
Basically, they're checking the SAFE Act and part of the CCIA.
The district court denied appellate's motion for preliminary injunctive relief on
All right, I can explain this. Basically, what the district court says, they are unlikely to succeed on the merits of the case because they lack standing as individuals to challenge New York laws regulating any of the stuff.
Wow.
So basically, it was thrown out for lack of standing. So therefore, they didn't have standing. Therefore, they weren't likely to succeed. They also weren't likely to succeed on the merits of the case. And this is the big one here.
We have appellate jurisdiction over denial of a motion for preliminary injunctive relief. We review this district court's decision on motion for preliminary injunction for abuse of discretion. A district court abuses or more precisely exceeds its discretion when its decision rests on error of law or clearly erroneous factual finding. It cannot be located within the range of permissible decisions.
And then it always goes, it's going to go down to explain what a preliminary injunction is, which if you watch my channel, you know what a preliminary injunction is. And it basically says that it is not a right to get a preliminary injunction. It's an extraordinary step to get a preliminary injunction. So go to appellate.
Appellants argue that the district court erred in rejecting the merits of their derivative Second Amendment claim, federal preemption claim, and self-incrimination claim in holding that they lacked standing to assert Second Amendment claims as individuals, and in rejecting their plea of irreparable harm in absence of an injunction because we concluded that the district court correctly assessed the merits and standing. We do not reach the issue of irreparable harm.
So they're rejecting the preliminary injunction there because they say that there is no irreparable harm for taking away someone's rights.
Wow.
Okay. The derivative Second Amendment claim.
Appellants first claim that the New York law is too onerous and it will put them and other firearms dealers out of business and thereby threaten their customers' Second Amendment right to acquire firearms. We have no trouble concluding that the appellants have standing to bring such a derivative claim. Vendors and those in like positions have been uniformly permitted to resist efforts at restraining their operations by acting as advocates of rights of third parties who seek access to their market or function.
Okay, basically they're saying they do have standing to sue on this, but we go over several circuits have extended.
Several circuits have extended that principle to purveyors of firearms and ammunition and follow suit, holding that a would-be operator of a gun store had a derivative standing to assert the subsidiary right to acquire firearms on behalf of his potential customers.
Yeah, that was based on the Maryland shall issue case that was just issued.
Holding
And
that a firearms dealer had derivative standing to challenge restrictions on potential customers' right to acquire firearms.
that's Ezel. That's Rhonda Ezel's case. Rhonda
Okay.
is a freaking fantastic person. If you don't know who Rhonda is, I've
Okay.
got her on the stream several times. She is a good friend and a fantastic person.
Holding that a supplier of firing range facilities had standing to challenge a Chicago ordinance that burdened its potential customers' firearms training.
That's because Chicago tried to ban all shooting ranges in the city.
Without questioning appellate's derivative standing, the district court held that there was no basis for their novel theory that the New York law violated their customers' right to acquire firearms by imposing too many burdens on them as commercial dealers. We conclude that there is a sufficient basis for that theory, but we hold that the appellants are not entitled to preliminary injunctive relief as the district court found in its irreparable harm analysis, a finding that likewise bears on the merits of appellants' derivative claim. Appellants failed to show that they would suffer the type of burden that is required for their derivative claim to succeed.
So basically, what they're saying here is, yeah, they're probably right, and this probably is unconstitutional, but it didn't rise to the level of showing that it would have caused irreparable harm. Even though, for me, a deprivation of a right is always irreparable harm, but that's just me.
Wow. The Second Amendment provides a well regulated militia. Being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. U.S. Constitution, Amendment 2, District of Columbia v. Heller, the Supreme Court held that the Second Amendment codifies pre existing individual right to keep and bear arms for self defense in case of confrontation, a right that is not limited to service in an organized militia. In doing so, the court observed several limitations on the right. Importantly, the court made clear that nothing in its opinion should be taken to cast doubt on laws imposing conditions and qualifications on the commercial sale of arms. The court identified such regulatory measures and others as presumptively lawful. 2 years later, when the Supreme Court held the Second Amendment is fully applicable to the states in McDonald versus Chicago.
Mr. McDonald passed away not too long ago. Rest in peace.
The court's principal opinion repeated Heller's assurance concerning the presumptive constitutionality of laws imposing conditions and qualifications on the commercial sale of arms. Quoting Heller, nothing in the court's more recent decision in New York State and Rifle Pistol Association versus Bruin cast doubt on the understanding of the Second Amendment scope.
That was Kavanaugh in his concurring opinion. Keep on going.
Okay. Still, the presumption of legality can be overcome. The Second Amendment, as interpreted by the Supreme Court, forbids a state from banning the in-home possession of common use weapons by law-abiding responsible citizens, Heller, and requiring them to show a special need to carry such weapons outside the home, Bruin. A state cannot circumvent those holdings by banning outright sale or transfer of common use weapons and necessary ammunition, as the Tennessee Supreme Court.
Yeah, basically they're saying that, but since you can still transfer it, it's A-okay. All right, just go down to here.
It follows that commercial regulations on firearm dealers whose services are necessary to a citizen's effective exercise of Second Amendment rights cannot have the effect of eliminating the ability of law-abiding responsible citizens to acquire firearms. For example, when the Supreme Court recognized a right to abortion, it correspondingly recognized that the state cannot circumvent the 14th Amendment's prohibition on abortion bans by imposing unnecessary special regulations on abortion providers as a class that had the purpose or effect of presenting substantial obstacles to a woman seeking an abortion. Such would constitute an undue burden on the right.
But then it was abrogated by Dobbs, which is kind of funny that they mentioned that.
It is indeed a fundamental principle of the Constitution law. What cannot be done directly can be done indirectly. The Constitution deals with the substance, not the shadows. Explaining separation of power concerns.
All right, just go down still. Appellant.
Still, appellants have not shown that New York law is so restrictive that it threatens a citizen's right to acquire firearms. To that end, we find the Ninth Circuit's en banc decision, Texria, persuasive. At issue in Texria was an Alameda County zoning ordinance that prohibited gun stores within 500 feet of schools, daycare centers, liquor stores, or establishments serving liquor. Where am I? I lost my spot.
Other gun stores in residentially zoned districts. Prospective vendors challenged the law, claiming that it violated their potential customers' right to acquire firearms and ammunition because the ordinance made it impossible to open a new gun store in Alameda County.
Wow. The district court dismissed the complaint, and the Ninth Circuit affirmed. The Ninth Circuit recognized, as we do today, that the Second Amendment protects ancillary rights necessary to the realization of the core right to possess a firearm for self-defense, and explained that the Second Amendment right to keep and bear arms for self-defense wouldn't mean much without the ability to acquire firearms.
All right, so basically you're saying that that's what happened in Texas. All right, now go here.
There is even less evidence here than in Texria that the New York citizens will be meaningfully constrained, or for that matter, constrained at all, in acquiring firearms and ammunition.
Basically,
claim,
it's saying that the citizens can still buy firearms, and it's not going to put anyone out of business. So basically, they denied the claim on that, and it just goes into more and more of why that isn't. Now, preemption.
Appellants claim that several provisions of the New York law are preempted by federal law, and that law thus violates the supremacy clause. The district court thoroughly examined and rejected each of the appellant's theories of preemption and perceive no error.
Like I said, that was their weakest. That was their weakest claim there, and they're saying that it did not violate preemption because they're not subject to preemption because the law does not interfere with federal law.
Appellants challenge New York general business law, which requires them to implement a security plan satisfying certain minimum specifications for securing firearms, rifles, and shotguns, including while those firearms are in shipment. Appellants assert that whatever conflicts with federal law because when FFL ships a firearm to another FFL, makes both FFLs responsible for maintaining a security plan while those firearms are in shipment, whereas federal law only makes the transferring FFL responsible for firearms that are in shipment. In support of that theory, they cite 18 U.S.C. 923, but neither supports that theory.
Both provisions?
Both provisions require FFLs to report firearms that were lost or stolen from their inventory or collection to the Attorney General and appropriate local authorities within 48 hours, and the federal regulation provides that when a firearm is stolen or lost in transit on a common contract carrier, which for purposes of this paragraph includes U.S. Postal Service, it is considered stolen or lost from the transfer sender licensee's inventory for reporting purposes. Therefore, the transfer sender of the stolen or lost firearm shall report the theft or loss of the firearm within 48 hours after the transfer sender discovers the theft or loss In other words, under federal law, it is the transferring FFL who must report a lost or stolen firearm. Nothing about New York law alters that duty, poses an obstacle to an FFL fulfilling that duty, or allocates responsible in a way that conflicts with federal law. To that extent, the New York law imposes additional duties on the transferee FFL. There is no conflict between federal and state law.
Basically, New York says both of them have to take responsibility for that. Federal law says it's just a transfer. The circuit court is basically saying, yeah, transfer is still responsible, but New York is allowed to add extra duties, which is crazy.
Next, appellants claim that New
Just
York
what a New York business law requires.
New York general business law requires firearm dealers to establish and maintain a book or electronic based record of purchase, sale, inventory, and other records at the dealer's place of business in such form and for such period as the superintendent shall require. Among other information, those records must include, at minimum, the make, model, caliber, gauge, manufacturer's name, serial number of all firearms, rifles, shotguns that are required or disposed of not later than 1 business day after their acquisition or disposition, an accounting by means of a monthly inventory check of all firearms, rifles, shotguns acquired but not yet disposed of, the firearm, rifle, shotgun disposition information, including serial numbers of firearms, rifles, shotguns, dates of sale, and identity of purchasers, and records of criminal firearm and rifle shotgun traces initiated by the ATF.
So basically, what they want you to do is you have to do an inventory every month, which most gun stores don't do. And every time you do a trace, you have to keep a record of you doing a trace. That is so they can come back and say, hey, you did this many traces. We're going to shut you down because we think you're illegally trafficking firearms. That's the whole entire reason. They're not saying that out loud, but that's the part that they want to. That's
Well,
what they're doing.
it sounds also like a registry.
Yeah. However, New York.
However, and central to the appellant's theory of preemption, while New York law requires firearms dealers to semi-annually report their records to the state police, federal law does not. Moreover, federal law expressly prohibits the Attorney General from enacting any rule or regulation requiring such reporting or otherwise establishing system of registration of firearms, firearm owners, or firearms transactions or dispositions. According to the appellants, if the Attorney General cannot require FFLs to semi-annually report their disposition records or establish a firearm registry, neither can New York.
So it's basically saying federal law says that. But what they're saying is that that's federal law. This is not state law. State law doesn't touch on that. I mean, the federal law doesn't touch on states being able to do that. And we're going to rule that states can do that.
Wow. Finally, appellants challenge that New York executive law and New York penal law on the ground that they will result in a misuse of the federal background check system, NICS, and therefore are preempted.
Basically, they're saying that, hey, NICS isn't supposed to be used for ammunition, but they're making people use NICS for ammunition.
Federal law prohibits certain classes of people like felons, drug addicts, mentally ill from purchasing, possessing firearms or ammunition. Concomitantly, federal law prohibits any person from selling or otherwise disposing of any firearm or ammunition to individuals whom they know or have responsible cause to believe fall within those classes of people. As a special check, federal law requires FFLs to submit certain identifying information of a buyer or transferee to NICS, which is maintained by the FBI, which in turn checks database known as NICS index for whether federal law prohibits the buyer from transferee from possessing a firearm. While the FBI ordinarily conducts that check, a state may alternatively designate a law enforcement agency as a point of contact to serve as intermediary between the FFL and the federal database checked by
Called a
NICS.
single point of contact. We actually had the discussion on DLD After Dark last night. I explained the whole entire how it works.
Mm-hmm.
Basically, what a single point of contact state is you actually go through, instead of doing a state background check and a federal background check, you submit everything to the state, and the state will also run the federal background check.
Yeah, and that's what they do in Florida.
Yeah. So what they're saying, go down importantly.
Importantly, as a point of contact may not purposely use the NICS for unauthorized purposes, access to the NICS index for purposes of unrelated NICS backgrounds check is prohibited unless for providing information to federal, state, tribal, or local criminal justice agencies in connection with the issuance of a firearm-related or explosives-related permit or license, including permits or licenses to possess, acquire, transfer a firearm, to carry a concealed firearm, or to import, manufacture, deal in purchase of explosives. Responding to an inquiry from the Bureau of Alcohol, Tobacco, Firearms, and Explosives in connection with a civil or criminal law enforcement activity relating to the Gun Control Act or the National Firearms Act, or
Or
disposing of
firearms, transferring firearms. They claim that it's the misuse of NICS, but they're claiming that Paloma did not explain why, even though they're saying, hey, this is the reasons why the NICS is supposed to be used. It says nothing about ammunition, and you're telling us to use it. But apparently the court didn't see it that way. So go ahead.
Appellants seem to have taken issue with New York law directing FFLs to initiate background checks through state police for ammunition sales. In particular, appellants speculate that when conducting background checks for ammunition sales, the state police will use the NICS index checks that are not expressly authorized for federal law and thus claim unlawful. But even if such use would be unlawful, New York law authorizes no such thing. New York law requires firearms and ammunition dealers to initiate background checks for ammunition sales through a statewide license and record database maintained by the state police, not through the NICS index, before transferring information to a non-dealer.
Even though that the state police actually run them through NICS, they're saying with the FFL's not doing that, so you have no standing to sue. Therefore, we're going to reject this part of the injunction that you seek. So now let's go to the appellant.
Appellants proceeding now as individuals claim that New York law violates their Second Amendment right by requiring them to obtain a license to possess semi-automatic fire rifles, undergo background checks to purchase ammunition, undergo firearms. Where are we? Training to renew their concealed carry license. The district court held that the appellants lacked Article 3 standing to challenge each law, and we agree.
Basically, what they're saying is that it doesn't matter what if it's actually violating their rights or not. They don't have standing to sue. You have to have standing to sue, and they're trying to say that none of the plaintiffs have standing to sue over these restrictions. So they're saying that they don't have to even look at the facts or determine if it's constitutional or not, because they just don't have a standing to sue.
So in conclusion, we have considered appellants' remaining arguments on appeal and find them to be without merit. Accordingly, we affirm the district court's order denying their motion for preliminary injunctive relief.
Okay, this is a 3-judge panel. And so the plaintiffs have a couple different John is a better reader and pilot. So they have a couple different choices. They could ask for an en banc hearing, which means a full bench will hear the case. I do not believe that they're going to do that, because the Fourth Circuit, as I said earlier on, is a very left-leaning circuit. So I think what is going to happen is they're going to go directly to SCOTUS.
Wow.
So I think they're going to go directly to SCOTUS and file what's called a writ of certiorari. I'm not sure if this one will be granted or not. It could be. It might not be. I don't know, but we will not find out until until the fall, not the fall, the spring. If it's
So,
granted cert, and then if it
sir,
is granted cert, then oral arguments will be next fall.
Wow.
And
So
hopefully we have
basically, that kicks the can down the road a year.
about a year and a half, because then
So
you have to wait for the ruling.
can I buy Clarence Thomas a gym membership? Is that okay?
Yeah.
You
There's
might
the
also.
boys. I met them at IV88
Oh,
and XCal
hey,
twice. No.
how's it going, guys? Yeah, I was
Yeah.
talking to the dad.
Yeah. So there you go. So it is definitely going to be interesting. Discretion means exactly what it is. The courts have discretion over how it rules. It's not like they can push it not as far as they want, because they're legally bound, but there's some wiggle room in there.
So what I'm reading is, if we're talking about a person of color wanting to ride at the front of the bus, this is saying, hey, you can still walk there. You don't even have to ride the bus. What are you talking about sitting wherever you want on the bus? You can walk.
Yeah.
That's really what this is saying.
Yep. So let's get to the starred comments.
Well, okay then. Let's see. All these ammo background checks, do they require a background check for buying primers or other reloading components? Good question.
I'm not sure about that. I'm gonna have to check into that. That
I'm
is a
not
good
sure.
question.
So I wasn't reloading when I was in New York, and I believe at the time when
ammo
they came
background
out,
checks didn't start until September
September when?
this year.
Really? Oh, I thought that was for years
No.
when the Safe Act came out. Because
No.
I just stopped buying ammo in New York. I traveled enough; it was convenient for me not to buy ammo in New York.
No. Let's get this done. Then I'm gonna get out of here because I'm tired.
Living in Rochester, I'm fairly certain there are more illegal guns in the city than legal firearm owners. Laws bark up the wrong tree. Amen, brother. You're 100% correct on that.
Then Garth says, "Sorry."
Ammo ID checks started in September. Okay. Alrighty.
There you go.
I thought it was years ago. Is this in New York, the background check for ammo? Yes.
Yep. And I think that's it. All right, guys, that's it. We're gonna get out of here. But hopefully this will be my last video of the night. I'm not gonna do video. I have a question. Do you guys think that we will ever stop giving our rights away out of fear of incarceration? Most of the time, no. All right, guys, that's it. You guys have a great night. Remember to vote for me at thegundies.com. Sorry, I'm kind of out of it. I'm just tired, and I got to write more articles tonight. December's always suck for me. Yeah. All right, guys. I love you guys, and remember, guys.